Welcome to the next episode of Small Business Legal Tips. I'm attorney Mark Bross of Bross Law LLC. I'm a practicing business attorney with over 15 years of experience helping Massachusetts small business owners protect what they've built. Now, here's something I hear from business owners all the time. They say, Mark, I formed an LLC, so my personal assets are protected, right? And my answer is probably, but only if you're running that LLC in the right way. Because here's what most business owners don't know. Massachusetts courts have a specific legal tool that lets creditors reach right through your LLC and go after your personal assets. That tool is called piercing the corporate veil. And the part that surprises most people, you don't need to commit fraud in order to trigger it. Small, repeated bad habits, things you might be doing right now, can be enough to let a creditor go after your personal assets. In this video, I'm going to walk you through exactly how Massachusetts courts decide to pierce the corporate veil, what real business owners got wrong, and a quick self-audit you can run on your own LLC to see whether you're at risk. And please, if you find this tip helpful, please feel free to subscribe and hit the like button for more helpful legal tips like this one. It really helps the channel and lets me know you'd like to receive more helpful legal tips like this one. So let's get to it. So first, let's talk about what an LLC is actually supposed to do. When you form an LLC in Massachusetts under M.G.L. Chapter 156C, which is the limited liability company statute, the law gives you something really valuable. It creates a separate entity that puts a legal wall between your business and your personal life. I talked about this more in a couple earlier videos, and I'll put a link to those videos below. But the idea is that if your LLC gets sued or your LLC owes a debt, the creditor is supposed to be limited to whatever assets the business has, and the business is responsible for them. A potential business creditor shouldn't be able to touch your home or other personal assets, such as your personal savings accounts, unless they are being used in connection with the business. That protection is often the whole reason why most small business owners form an LLC in the first place. But here's the thing. As I've discussed in the earlier videos, that protection is not bulletproof. There are some statutes, such as the Massachusetts Wage Act, where officers, directors, and shareholders can be held personally liable if they are actively involved in the business. Also, for some specific contracts, such as leases with landlords or loans from banks, the other party may require that the LLC's members provide a personal guarantee to secure the debt or the obligation. In these cases, the other party is trying to ensure that they will get paid, and since you normally need the money or the space, you agree that you'll be personally liable even if the LLC fails to pay the debts. But even if we put aside those rare statutes or contracts, there are also other situations where courts in Massachusetts will ignore the wall between the LLC and your personal assets if they believe your LLC was never really a separate entity to begin with. The legal term for ignoring the separate entity wall is piercing the corporate veil or finding alter ego liability. And the way Massachusetts courts decide whether to pierce the corporate veil comes from a seminal case from 1968 called My Bread Baking Company versus Cumberland Farms, Inc., as interpreted by a leading federal court case. And there are 12 factors that Massachusetts courts look at today in deciding whether to pierce the corporate veil. The first factor is whether there is common ownership between the LLC and its owner, which means whether the LLC and its owner have the same owner themselves. The second factor is whether there is pervasive control by the owner over the LLC. The third factor is whether there is a confused intermingling of business assets with the personal assets of the owner. The fourth factor is whether there is thin capitalization, which means that the owners did not provide enough capital to the LLC when it was formed in order to successfully operate the business. The fifth factor is the non-observance of corporate or LLC formalities in connection with the LLC. The sixth factor is the absence of corporate or LLC records. The seventh factor is no payment of dividends or owner distributions to the owners of the LLC. The eighth factor is the insolvency of the LLC at the time of the disputed transaction. The ninth factor is the siphoning away of the LLC's assets by its dominant owner. The 10th factor is the non-functioning of any officers, directors, or managers of the LLC. The 11th factor is the use of the LLC for personal transactions of the dominant owner. And the 12th factor is the use of the LLC in promoting fraud. Now, you don't need to memorize all 12 factors. The basic idea behind each one is whether you are treating the LLC as a real separate entity with its own rights, assets, expenses, and contracts, or whether you're simply treating the LLC as an extension of yourself. But when deciding whether to pierce the corporate veil, courts will look at all these factors and balance them in deciding whether to go after your personal assets in order to satisfy a business creditor. And the more you fail to treat your LLC as a real separate entity with its own rights and ongoing requirements, such as by failing to file annual reports, failing to keep adequate records, or using LLC's assets for your own personal expenses, will count against you. And here's the most important thing to understand. You don't need to fail all 12 factors for the courts to pierce the corporate veil and go after your personal assets. They simply balance all of them, and a pattern of small mistakes repeated over time can add up fast. So now that you know about how Massachusetts courts think about this, let's look at what a real Massachusetts business owner actually did wrong. Let's take a look at a case called NuVasive Inc. versus Rival Medical LLC. This was recently decided in 2024 in the U.S. District Court for Massachusetts. In this case, NuVasive was the plaintiff, the company that sued. Rival Medical LLC was the defendant and the LLC whose veil ultimately got pierced. And it is one of the most recent, clearest examples of how everyday business behavior can destroy your LLC protection. Here's what happened. NuVasive had obtained an arbitration judgment against Rival Medical for around $617,000, including interest, for a breach of contract. They are trying to enforce that judgment against Rival Medical, but Rival Medical claimed it didn't have the money to pay. So, NuVasive sought to pierce the corporate veil and enforce the judgment and obtain the money from the owners of the LLC. And the court allowed it after considering the following my bread factors. First, the court found that Rival Medical observed some corporate formalities because it regularly filed annual reports, had a separate bank account, separate credit cards, financial records, and filed its tax returns. This factor counted in favor of not piercing the corporate veil. Second, the court found that Rival Medical did not have sufficient corporate records, however, because it did not have an operating agreement or a writing that sets forth who the members or managers were, how much they contributed, when contributions would be made, and what would happen if the LLC was dissolved. Massachusetts law does not require an operating agreement for your LLC, but it does require a writing that sets forth that specific information. Rival Medical did not have this writing, and so it failed to have proper corporate records. This counted in favor of piercing the corporate veil. Third, the court found that Rival Medical did not have any evidence of paying dividends or distributions to its sole owner. According to the court, LLCs should pay their owners dividends or distributions or have some record indicating a conscious decision not to do so. Rival Medical did not have any of that, so this was another factor in favor of piercing the corporate veil. Fourth, the court found that Rival Medical was thinly capitalized because the owners only provided $15,000 in capital to the company, which was insufficient to cover its short-term expenses or the sustainability of the company. Rival Medical had over 15 employees and other expenses, and the $15,000 would not even cover 1 month of its employees' salaries. So this factor also counted in favor of piercing the corporate veil. Fifth, the court found that Rival Medical was insolvent at the time of the litigated transaction because it struggled to pay its debts when they came due. Rival Medical was operating at a net loss when it entered the contract with NuVasive in January 2019, and it was unable to pay its employees 2 months later. This also counted in favor of piercing the corporate veil and finding the individual owner liable for Rival Medical's debts. Sixth, the court found that Rival Medical did not have functioning officers and directors because the owner's spouse, who was the manager of the LLC, was not actively involved in the operations of the LLC. She did not know if Rival Medical had any bank accounts or credit cards, did not sign any contracts, and did not participate at all in any of the company's votes or its activities. As a result, this was another factor that counted in favor of piercing the corporate veil. Seventh, the court also found that Rival Medical commingled business assets and expenses with personal assets and expenses of the owner. Rival Medical's owner occasionally received commission payments owed to Rival Medical in his personal bank account rather than Rival Medical's bank accounts. Also, the owner used Rival Medical's funds and credit cards to pay for his own personal expenses, such as insurance for his mother, travel expenses, and utility and maintenance expenses for a vacation home. None of these were related to the business in any way, and so this was another factor in favor of piercing the corporate veil and finding the owner personally liable for Rival Medical LLC's debts. Eighth, the court found that Rival Medical's dominant owner siphoned away Rival's corporate assets for his own personal benefit. He continually used Rival Medical's business credit card for his own personal purchases like vacation trips and continued to make cash withdrawals from Rival Medical's business bank accounts even though Rival was no longer operating. Yet again, this factor counts in favor of piercing the corporate veil. Ninth, the court found that Rival Medical's dominant owner exercised pervasive control over Rival Medical because the owner controlled every single aspect of the LLC. As a single-member LLC, this was not really a surprise, and the court wanted to view this factor with a grain of salt. However, in light of the other factors, particularly the LLC's failure to follow corporate formalities or have any corporate records, the court also considered this to be another factor in favor of piercing the corporate veil. And finally, the court also found that the owner acted in a blameworthy manner by causing Rival Medical to breach the agreement with NuVasive and disregarding his non-compete agreement to NuVasive. After closing Rival Medical, the owner started up a new business that did the exact same thing as Rival Medical, that went to work for another company that competed with NuVasive. Yet again, this factor counted in favor of piercing the corporate veil and finding the owner personally liable for Rival Medical's debts. In light of how all these factors came out, it's no surprise that the court decided to pierce Rival Medical's corporate veil and find the owner personally liable for NuVasive's judgment against Rival Medical. Rival's owner was completely in control of all aspects of Rival Medical's operations, caused it to breach the agreement with NuVasive, and continuously used Rival Medical's bank accounts and credit cards over time for his own personal expenses and use. This is exactly what you want to avoid. So let's talk about what actually happens when a Massachusetts court decides to pierce the corporate veil, because I want you to understand that this is not just a legal concept, but it is a real financial outcome that affects real people. When a court pierces the corporate veil, it is setting your LLC aside entirely. That business entity, the thing you filed paperwork to create, the thing you hopefully paid annual fees to maintain with the Massachusetts Secretary of State, the court is essentially saying it doesn't count and no longer exists for the purposes of this debt. You and the LLC are now considered to be the same person, and you can now be held liable for the LLC's debts and liabilities. So what does that actually look like in practice? The process is actually fairly complicated, as debtors actually have a lot of protections in Massachusetts, which is really no surprise. But generally speaking, the creditor can now go after the following items. First, a creditor can now go after any money in your personal bank accounts to satisfy the judgment. Your personal checking account, your savings account, any money you've set aside for your family, and any money you have stored anywhere else. A judgment creditor in Massachusetts can seek to attach those funds directly through a process called trustee process attachment. Massachusetts law exempts up to $2,500 in cash or savings, but anything more than that is potentially at risk to satisfy the judgment creditor. Second, a creditor can also now go after any other personal property you own, such as vehicles, personal computers, furniture, TVs, phones, and any other personal item. Many of these items have a dollar value exemption under Massachusetts law, where the creditor can only seize and sell the asset if its value is more than the exemption. For example, the exemption for cars is $7,500 wholesale, so if your car is worth more than $7,500, it can be seized and sold by the creditor, although the $7,500 will be returned to you. Third, a creditor can also put a lien on any real estate that you own, including your home. That means if you ever try to sell your home to a third party, that lien has to be paid off first. In some situations, a creditor can push further than that, although Massachusetts homeowners have a strong homestead protection that can protect up to $1 million in equity or cash in your home, and that will prevent creditors from taking your home to collect any debt. This exemption only applies to your primary residence, though, and not any other real estate that you own. Other real estate, such as a vacation home, can be seized by a creditor and sold to collect on the debt. Fourth, a creditor can also potentially garnish your wages by using trustee process attachment. So, if you work and draw a salary from another job or another business, that income can now be reached, although the maximum amount of wage attachment is limited by statute. In Massachusetts, you can keep the highest of 85% of your earned wages before taxes, or 50 times the minimum wage, and the creditor can only attach what's left. As I mentioned, the law here is a little bit complicated because debtors have very strong protections in Massachusetts. So if you're actually facing a debt collection problem or you're trying to enforce a judgment, speak with a knowledgeable attorney. Now, With respect to the NuVasive versus Rival Medical case, we don't actually know at this time what's been done. But NuVasive can now use any of these options to actually enforce the judgment and collect the debt that's owed from Rival Medical's owner. Here's the good news. Fixing this problem or preventing the problem is not all that complicated. You don't need to overhaul your business. You just need to build a few consistent habits to make sure you're following all the rules that you need to follow in connection with your LLC to make sure that your LLC is treated as a real separate entity apart from you. So let me walk you through a quick self-audit. 6 checks you can run on your LLC right now to see whether there are some things that you need to fix in order to prevent any possible piercing of the corporate veil. And before I do this, let me be clear. This is general guidance for Massachusetts LLC owners, not legal advice tailored to your specific situation. If you want a full review of your records, your contracts, and your past practices, consult with a knowledgeable attorney. But this checklist will give you a strong starting point to see whether you might need to retain an attorney to help you out. Check 1. Separate bank accounts. Does your LLC have its own dedicated business checking account that's in the LLC's name? Every dollar that comes into or goes out of the LLC should flow through that account. Not your personal checking account, not a shared account, a clean, separate business checking account that's in the LLC's name. If you're using one account for both personal expenses and business expenses, that is the first thing to fix. Go open a business account this week. To do that, you'll probably need to obtain an EIN from the IRS if you don't already have one, but that's easy enough to do. I'll put a link below to the website as to how do you obtain the EIN for the IRS. Check 2. Separate credit cards. Does your LLC have a business credit card that's used exclusively for business expenses? If you have a business credit card, you should only use it for business expenses. Don't use it for groceries, for takeout orders, for any kind of streaming services, or anything like that. Use your business credit card for business expenses and only for business expenses. Similarly, if you have a personal credit card, you also should not use it for business expenses. Sometimes when you're first starting up and you don't have a business credit card, you might use your personal credit card for business expenses. That's okay in just the beginning, but you shouldn't continue to do that for any kind of long-term period. After the business has been up and running for at least 6 months to a year, the business should have its own business credit card, and that's the card you should use for business expenses. Using the business card for groceries or streaming services, even once a month, starts building the wrong picture and over time can really count against you. Check 3. Annual LLC maintenance. Is your LLC up to date on its annual reports? Every LLC is supposed to file an annual report each and every year on the anniversary date of its formation. I just posted a recent video about how to complete and file your LLC annual report, and I'll put a link to that video below. Failure to file your annual report will lead to administrative dissolution after a couple of years by the Secretary of the Commonwealth of Massachusetts. And even if it hasn't been dissolved yet, it's a clear sign that your LLC is not being treated as a real entity with its own rules and requirements. Check 4. Corporate records. Although an LLC is not a corporation, it is required by M.G.L. Chapter 156C, which is the Massachusetts Limited Liability Company Act, to keep certain records. These records include the following. First, a current list of the full name and last known address of each member and manager. Second, a copy of the certificate of organization and all certificates of amendments along with any powers of attorney that affect the LLC. Third, copies of the LLC's federal, state, and local tax returns for the past 3 years. Fourth, copies of any operating agreement and any financial statements for the past 3 years. Fifth, if you don't have an operating agreement, you need to have a writing that sets out the following things: the amount of cash or property or services that are being contributed by each member to the LLC, the times and circumstances when members will make additional contributions, any rights of a member to receive distributions or a manager to make distributions to the members, and any events when the LLC is going to be dissolved. All of these records must be kept in the LLC's registered office somewhere in the state of Massachusetts. If you don't have any of these records, you don't have any of the necessary records for an LLC, and you're not treating your LLC as a real separate entity. Check 5. Contracts and signatures. Pull out your last 3 contracts right now. Look at the signature line. Whose name is on it? If it just says your personal name with no title and no LLC name attached, that is a problem going forward. Every contract your business signs should clearly show the LLC as a party to the contract. The signature block should say something like, quote, ABC Consulting LLC, John Smith, manager. end quote, presuming that you're the manager of the LLC. If your LLC does not have a manager, you should just simply say authorized representative after the person's name. And that tells everyone that the LLC is bound by this agreement and not you personally. Check 6, capitalization. Have the owners contributed enough money for the LLC to succeed? One pattern courts flag is when the owners of an LLC do not contribute enough money for the LLC to succeed without financial difficulty. Unfortunately, there's no bright line test here about how much money is needed for the LLC to have sufficient capitalization for the LLC to succeed. The amount of money that needs to be contributed will vary from business to business. For example, an owner of an LLC with 3 employees will need to contribute enough capital at the very beginning to cover these employee expenses for a reasonable number of months until the business generates enough money to pay them. But the owner of an LLC that's devoted to dog walking with no employees does not have to contribute too much money to the LLC except for whatever insurance is needed and enough money for a good pair of shoes and a couple of leashes. So it all depends on what the business of the LLC does. But if your LLC is set up from the very beginning so that it's always on the brink of failure, or if the LLC's owners are always taking out capital draws that leaves the company without a reasonable financial safety net, that's a sign that your capitalization could be a problem. So, in conclusion, an LLC is a fantastic legal entity that can serve as a legal shield to protect your other personal assets from the debts and liabilities of the business. But this protection is not foolproof, and you must treat the LLC as a real separate entity and not your personal piggy bank. Your LLC shield is only as strong as the habits you build around it. That is the one thing I want you to take away from today. Piercing the corporate veil often doesn't result from one big act of fraud. It often results of small, repeated bad habits multiplied over time. The failure to file your annual reports, a personal charge here, an unsigned contract there, an account that mixes business and personal money. Each one feels minor in the moment, but together they can hand a creditor exactly what they need and lead to personal liability for you and your family. So here's your homework. Go look for your LLC's records right now and pull your last 3 business credit card statements. Are you missing any of the required LLC records? Are there any personal charges on your business credit card statements? If the answer to either question is yes, fix the problem today. Not next month, today. And if you need any assistance or want a full compliance review of your Massachusetts LLC and your past practices, reach out to Brassall LLC for a consultation. We'd be happy to help. The link is in the description. I hope you found this information helpful. If you found it helpful, please like the video, subscribe to the channel, and share it with another Massachusetts business owner who needs some help. Thank you so much for watching, and I'll see you in the next episode of Small Business Legal Tips.